Your Honor, that concludes our 9 a.m. docket.
Mr. Shima. I'll now call counsel forward on 122156 State versus Couch. Whenever you get settled, Mr. Mann, you may come to the podium.
Good morning, Your Honors. And may it please the court, Kai Mann of the Appellate Defender Office on behalf of the appellant Michael Couch. Reaffirm I have 3 minutes for rebuttal and get into the argument. Because his unqualified right to represent himself was violated, constituting structural error, Mr. Couch respectfully requests this court remand this case to the district court for a new trial. But because the prosecution failed to present sufficient evidence of the kidnapping, and the district court failed to instruct the juror on the lesser included theories of aggravated battery, Mr. Couch requests this court vacate his kidnapping conviction completely and give specific remand instructions to the district court to instruct on the lesser included theories of aggravated battery. As such, I intend to discuss these issues, beginning with the right of self-representation, moving on to the aggravated kidnapping, then with the lesser included, with the caveat that I am still asserting that all of these errors, if not individually reversible, are cumulatively reversible. But beginning with the right to self-representation.
Before you start, Mr. Mann, reading the facts of this case and the behavior of your client in the pretrial proceedings, at trial, and everything leading up to his determination that he wanted to represent himself, was there any question of competency? Did that ever come into play that someone said that, hey, we need to check this out? I'm just curious. I didn't see it anywhere, but no. This kind of conduct and behavior in district court, I'm just wondering, did that happen?
Sure. No. The short answer is no, there was no competition. But if you mind if I expand on that a little bit, because
I don't mind. It certainly raised a question. What are we doing here with this kind of aggressive outburst kind of behavior that seems to have no kind of control over his impulses at all?
Well, and I understand, especially once we look at the briefs, because when you look at the briefs, you kind of get the feeling that this pretrial process started around volumes 13 and volume 8, when we're getting really close to trial, right? But if you actually look at the rest of the pretrial proceedings prior to Mr. Couch filing his motion to go pro se, he was not disruptive. He was not violent. He was not outburst. Yeah, there were some times where he would make some comments like, if you want to look at record 3, he was appropriate. He clearly wanted to participate in his defense. He thought that there were problems with the cell phone, that there were problems with DNA, but he didn't become violent and he didn't become truly disruptive to a point to where there would where we'd even begin to think about competency issues until after his motion was denied, when he was unable to represent himself. And I think that that's important, because at this point Mr. Couch said, I'm tired of lawyers. My prior lawyer was ineffective and he died, but I've got a new one and I still don't like her. Again, from Mr. Couch's perspective, and this might be a little bit colorful, but he's being frog marched down to the Star Chamber for a kangaroo court, and he's the only one who can save himself. So if he's not allowed to represent himself, which is an unqualified right, and since there is no issue of competency, that is the only minor, even possible exception to not allow someone to represent themselves. So at this point, he had no incentive to even try to contain himself, because, he was basically being thrown to the wolves, without being able to represent himself. So if we look at the entire pretrial proceedings, I don't think that we can say that, no, this is clearly a competency thing. I think, in fact, had Mr. Couch been able to have the ability to represent himself as the Constitution of Kansas and the federal government require, we probably wouldn't have had this problem, because, again, the right to represent oneself is unqualified, but it is not absolute. And I think Plunkett decided by the Court of Appeals and the state really offers a really instructive situation here. Because in Plunkett,
Can I ask you before
Yeah.
you get into that case law? I think you touched on exactly a question I had. Unqualified does not mean absolute. So if there was serious outbursts or disruptions, that's a legitimate basis to deny a timely motion for self-representation if it's supported factually.
close. The only disagreement I have with is that it is not a correct basis to deny a motion for self-representation, but once a party has been granted the right to self-represent, it is perfectly appropriate to terminate.
Well, federal courts have used that very basis to deny timely motions.
The timely motions filed before trial started.
Correct. That is the definition of timely, as I understand it.
I guess I was unaware of that citation because I've been going off Ferretta, which offers the appellant the unqualified right if they make the request before the request. Now, once you have the right to counsel and you representing yourself and you're disruptive and engaging, then Ferretta footnote 46, you can terminate. But to terminate, you have to be given the right. You just can't say you can never have it. You can give it.
At that point, it becomes an abuse of discretion standard, and there's a far more flexibility.
Correct. But if you never have it, then we're in structural error territory. And this was structural error because it was unqualified. He made the request before trial. It was not given, and so therefore we can't terminate. Now, again, Plunkett, he was given the right to
Let me
represent.
ask you, let me back you up. The question I really have maybe is on standard of review. If there is case law that suggests that serious disruption and outbursts pre-trial can be a basis for denial, our case law has said that we apply a de novo review here, but it seems to me when there are findings by a district court that are made to support a denial for a pretrial motion, shouldn't we, do you think we should apply a mixed standard of review there?
No, I guess I'm still a little bit confused between the difference between a denial and termination, because again, under the research that I've uncovered, I was unable to find anything saying that you can flat out deny a person their right to represent themselves. Now, once that right has been granted, and again, Plunkett, because in Plunkett, it was one hearing. From the beginning hearing, he was granted his right. Obstructive by the end of the hearing, it was terminated, and that's not an abuse of discretion. But what I'm saying is that the termination.
Let's just assume, because the 10th Circuit has said as part of the distinction between an absolute right, not an absolute right, but certainly unqualified, that serious disruption can be a basis. And I think the rationale is that may suggest that if that is the behavior you're dealing with, you can't really have an intelligent waiver of counsel. That's sort of that theory.
I understand, but then I think we're getting into the issue of more of the Williams and the Plunkett when we're dealing with severe mental illness, and we just don't have that type of a record in this case. Because again, the way I read Ferretta, which is the foundational case for this, is, you know, footnote 46 gets thrown out there a lot, which talks about the disruption and everything. But the sentence that footnote is appended to says that the choice of self-representation must be honored out of respect of the individual, which is the lifeblood of the law. Now, that footnote is talking about what if this is a terrible idea and this person can't do it? And that footnote is saying, well, yeah, if they can't do it, if they're constitutionally incapable, you can terminate. It's not absolute, but you have to allow them to represent. So again, I guess whatever 10th Circuit precedent may be out there saying that you can, without any competency or mental illness or severe mental illness issue, deny somebody the right to represent themselves at all, I think it just flies in the face of Ferretta and shouldn't be followed.
At minimum, doesn't the district court have to do the Ferretta hearing and make findings that there's a knowing intelligent waiver of the right to counsel? Maybe potentially make a finding that whether or not the request was unequivocal. And I'm going back to my question on standard of review, that if there are those types of findings connected to a timely motion, should our standard of review be mixed, meaning that, you know, the legal conclusions de novo, but the factual findings for substantial competent evidence?
I think that one could say that, you know, I think that, you know, because again, I can't remember the name. I think it's Professor McKissick that had the large article, or that gets cited over the advisements you have to give. You know, yeah, I think that once we're talking about whether or not a district court advised somebody correctly and whether or not the waiver was known and intelligent, then yeah, I think that's true. But we're not in this situation here because he was never given his right. So I just think that I just think those situations are beyond this case because Mr. Couch's right was violated. He was never given the opportunity, and the reasons he was not, as we argued under Bunyard, were improper because, again, decorum and his lack of knowledge, which again, had Mr. Couch been given the chance, it's not at all clear that this would have went the way it was. He was only that disruptive after he was denied. And when he testified in his own defense on day 4, he was relatively calm and able to proceed himself. Again, this isn't that Mr. Couch was unable to control himself at all. That may be the case, but we don't know because it just weren't given a chance. But he was never given the chance to actually be in control, to give him the incentive to actually comport himself. So I think that once we look at this entire record and see what happens, had Mr. Couch been given the chance to represent himself, I don't think we would have had the same degree of outbursts. And remember.
So are you asking us to make an inference that the reason for his outbursts was because he was denied the right to represent himself?
I think that is the most reasonable inference on the record because you don't have these outbursts prior to the time of him being denied to represent himself. All of this did not.
I'm confused because the trial judge found, and I went back to the record to get to make sure I was correct in this. When he denied the self-representation, he said, to be honest, in every hearing that we've had, other than the waiver of preliminary hearing, you have been disruptive of the proceedings. And frankly, you've been threatened with at least some form of contempt action on at least 2 occasions. That describes a different behavior than.
Again, and I actually read the entire pretrial proceedings yesterday, and I did not catch that. I did not catch Mr. Couch being violent and being super disruptive until around the time his motion was filed. You know, he would talk and he would make comments, but he wasn't threatening to attack people. He was trying to assist in his defense. And again, he was having problems with his lawyer. He didn't like the theories lawyers doing. He didn't like the advice his lawyers giving him.
But doesn't that I'm sorry, I don't.
No, you're fine.
Go ahead.
Excuse me.
Doesn't that disregard what the fact the judge was in the room and the judge didn't just hear what the words he said. He saw how it was said and he saw what the defendant's demeanor and made judgments based on everything that he saw and heard. So I'm not sure how you can reconcile the words with the judge's interpretation of what happened.
No, and I understand, and I see I'm running out of time. May I answer? Thank you. You know, and I think at this point, this is where we're going back to the difference between completely denying somebody a constitutional right. That, again, is such a bad idea, is under structural error, and terminating that right. Again, go back. I really suggest reading Plunkett, because in Plunkett, the defendant was granted his right to represent himself whenever requested, unqualified, proper. But by the end of the hearing, that right had been terminated. And that was wholly proper and affirmed by this court because he showed during that course of hearing. So once the right's given, it's not like you have to go until a new crime is committed. In fact, under Plunkett, the standard to terminate the right of self-representation is less than that would need to remove an unruly defendant from the courtroom. So the point of this case isn't whether or not Mr. Couch was going to make it to the end of the trial as his own attorney. But the fact of the matter is we have structural reversible error when the district court never gave him the chance to try.
Move you over to the charge. Could we look, when we're doing our review of that, look at the statute, or should we look at the jury instruction?
I think it depends on the particular case.
Well, I'm
No,
talking.
yeah, exactly. Yeah, yes. Sorry. If I had more time, I'd go off on the full spiel. But in this case, because the state made specific actions in narrowing the complaint, because they charged both commission and flight, but there's jury instructions said only commission, and their proposed jury instructions said only commission. They made no objection. Their arguments and closing argument and the rebuttal were focused solely on commission. So I think if the court were to go and expand the complaint back in a little bit, I think, one, you got a problem because then you're affirming on a theory that was never given to a jury. I think we have some lurking separation of powers issues here because the court is expanding the theory upon which the state is trying to gain a conviction, and that is solely their province to decide what theories and what convictions to go after. So I think in a situation like this, where the only reason it's different is because of actions by the state showing a conscious decision, then we need to go by the theory the state put before the jury.
And if we do that, then we look to the record evidence. And the one question that I had is when the Mr. Couch enters through an open garage door, breaks into the garage access door in the kitchen, which is where the victim's at. And then she is removed, and I'm looking at a map of the duplex here, to the back bedroom, which takes her away from the most accessible routes of escape, arguably, being the garage door and the front door itself. Is that enough to facilitate the subsequent sex crimes? Removing from her most immediately accessible means of escape?
I would say that under this court's controlling precedent currently, no. I would say that you know, if that's sufficient, then every other kidnapping that has been found to violate bugs would be sufficient. Because without some level of confinement, most of these crimes couldn't happen, right? Like, again, going back to Oldsman, a Court of Appeals opinion that was been cited again, it was also my opinion, so it's fresh in my head, but you know, that basically, you know, if you're going to kidnap somebody for a rape or a sodomy or any of these other crimes, and you didn't confine them, well, then there would be no rape or sodomy to begin with. So I still think that at that situation, unless you're actually has an immediate, you know, like clear impact on, you know, like, again, if there was a bunch of kids playing in the driveway, and so Mr. Couch moved her away. So, you know, specifically to lessen detection, but in this case, there's nothing indicating it was anything more than for his own comfort or incidental to the rapes and the sodomies.
And does the confinement have to facilitate a charge defense? And then I guess my second question about the evidence is the lotion and the hand wash that was taken after the tying up of the victim.
I guess it depends on what you mean by charge defense. You know, like I think this could be
Because the statute says facilitate facilitate a crime.
sure. So I guess, you know, to make an analogy, like let's say a single issue felony murder case, you know, felony murder done via intent to distribute drugs, but they didn't charge the intent to distribute drugs. Now, in that situation, the jury still has to be instructed on the elements of distribution to determine whether or not blah, blah, blah. So I think aggravated battery or aggravated kidnapping, the same thing, is that no, it doesn't have to be charged in the sense that you can have a single aggravated kidnapping case, but you still have to give the jury some sort of elements to determine whether or not another crime was being committed. And in this case, the only other elements that you could even possibly to do that. I mean, jurors, you just can't turn them loose on a transcript and say, hey, go find the crime. You know, they don't know the crime. That's why you need to give them the elements. So when we look at everything, the only possible crimes here were the ones that were also charged. If no more questions, I would just ask that this court vacate Mr. Couch's convictions, remand for a new trial on everything except the aggravated kidnapping. Thank you.
Good morning, Tamara Hicks for the state. This case, when they were discussing the pretrial, in the pretrial hearing, they were discussing the motion for the defendant to represent himself. During that hearing itself, his attorney was talking to the court, trying to explain to the court that she needed a minute to talk to her client and explain why she felt that he needed legal representation because of the complexity of the case and things of that nature. At that moment, before the judge ruled he couldn't represent himself, he said, if you don't effing shut up, I'm going to bite your face off, to his counsel, right there in court, in front of the judge, in front of everybody. So at that point, we had already seen behaviors that were inappropriate, aggressive towards the prosecutor and defense counsel. He would talk over the judge. He would just randomly start talking about whatever he was talking about. So it wasn't after he was told he couldn't represent himself. It was throughout the proceedings in this
Were you
case.
present for this, or
I-
I'm just,
Yeah,
don't-
I didn't try the case, but I was present for some of the hearing, and I heard the defendant tell the prosecutor he was gonna bend him over a table and put a toothbrush up his backside, that
So you were a witness to all this, and
A lot
I'm
of
just
it.
reading a record. The first,
Right.
and I went back, I just, why didn't the question of competency ever come up? I
Because-
don't
bec-
understand that, because it just seems like, at least from experiences I've had and others have had, when you're dealing with this kind of disruptive, lack of impulse kind of behavior, in my mind, you have to ensure this person is at least capable of representing himself and understanding the charges against him. And that seems to me it was never done.
there was no competency motion filed or any competency evaluation done in this case. The defendant was, at the time of this case, a criminal history A, and had been through several court proceedings. He was able to, he knew how the proceeding would go. He knew what the judge's job was. He knew all of the parties what they were supposed to do. And he knew what he thought he could do if he represented himself based on his statements to the court. Should a competency evaluation been done? Maybe so. Maybe so. But the whole series of him being upset seemed to happen after his original attorney passed away and he had to receive a new attorney. And from that point on, we saw the aggressive conversations where he would just spout off whatever he was thinking. He wouldn't be quiet as the judge was trying to make decisions or trying to explain to the parties how the procedure was going to work. It was to the point where the judge had made arrangements for the defendant to observe his trial by closed circuit, because every time we had a hearing, there was this explosion of the defendant over little things, over things that really had no bearing on his case. And so that was made available to him ahead of time. It was set up by the judge so that when this happened, he would be able to remove him from the courtroom so that the trial could actually go forward. If he were to be in the courtroom, he would continue to cause difficulties, which would cause the jury not to be able to hear the evidence, let alone let our witnesses say what they had to say to the jury. In addition, he didn't want to change out of his jail outfit and his shackles. He explained to the judge that he was afraid that if he wore regular clothes and had no shackles, he would hurt people in the courtroom, that he would rape people, that he would stab people. If he could find something to steal, he would steal it. So all along, he's telling the court that he is not able to represent himself because of these outbursts, because he didn't conduct himself properly in front of the court to be able to represent himself, or to question witnesses, or to present evidence to the jury in this case. So
Is that another way of, are you saying it's another way of him telling the court, I'm not going to follow the rules?
yes, exactly. And he basically, by telling his attorney to shut up over and over and over, by telling the prosecutor that he was going to call him a bitch in front of the entire proceedings, in front of the jury, all of those things. He was just doing what he wanted to do when he wanted to do it. He would stand up, he would throw his arms around, he would be quite aggressive, even in his personal space. He had no way of acting like a person should act if they're going to represent themselves.
So
So,
let me, if I may, kind of look at the case more globally, and I know we haven't really talked about it that much, but let's just hypothetically say that the aggravated kidnapping can't stand or can't, doesn't have sufficient evidence. And on the lesser included aggravated battery, under 1B, knowingly causing bodily harm with a deadly weapon, the lesser included, that was error not to give that instruction. So let's say we find those two errors. Why isn't there cumulative error in this case?
well, if you find that way, you have to have two or more things that make it cumulative. In this case, there was a lot of evidence that I believe support those two counts that you've said that if you find they can't stand that.
I'm just saying, assuming
Yes,
without deciding that,
Right.
that it seems like maybe almost a mistake in the jury instructions, because it seems like to facilitate flight was kind of left out of the instruction. And
Right.
that, okay, so we find that it was error, and there was insufficient evidence. And then on this aggravated battery, they didn't give the lesser instruction, which would have been a severity level. It would have been a 7 instead of a 4. So why doesn't that cumulatively require us to
well,
deprive of a fair trial?
I don't believe that the court would find those two situations, but if they did, I would argue that cumulative error means more than just two issues of either improper jury instruction or not giving the lesser. The lesser was not asked for by defense at the time, so
That goes to, I'm not even saying that
Right.
we would go to reversibility on those two errors.
Right.
Just saying that those, even if neither one of those errors were sufficient to reverse, I'm just saying, the cumulative error analysis is together, is it enough?
Right. And my argument is not enough because there was other evidence that was presented to the jury that would prove up those counts. As far as the aggravated kidnapping, the case law indicates that if there is something that makes the crimes easier for the defendant to accomplish. Well, in this case, he was not able to perform. He wasn't able to keep an erection, and he used the items that not only did he take from the house when he left, but he used those, a toothbrush from the bathroom that's right off that bedroom where he moved her to, as well as the toothbrush, which he anally sodomized her with. So our argument is that those things helped him and it made the crimes easier because he was not able to commit those crimes with his own personal.
Counsel,
body.
I understand the argument. In making that argument, it strikes me that you and the defendant as well are constrained and sort of struggling with this distinction that this court drew in Buggs between facilitate and convenience. And what I want to ask is, does that distinction make sense?
Not to me. If you are taking a person to another location to be able to commit your crimes, I think that Bug says you can't just take them somewhere. But that's exactly what they do. They take them away from the doors so they can't escape. They take them away from areas where people might be able to overhear screaming or yelling or call for help, things of that nature. So
Would you agree that facilitate is a common English word that jurors would have a common understanding of?
I think some jurors would, but I also think some jurors would not, based on their education, and they might have a different explanation of what
Well,
that might
do
mean.
you think that it's within the province of the jury to determine what counts as facilitate?
Yes, I think it has to be,
Well, Buggs says it's not, right?
right?
Isn't there a problem with nearly every rape then becoming a basis for aggravated kidnapping? That, at least that would be a concern I would have, is that if there isn't some form of distinction, the mere confining and maybe taking a victim 10 feet away from where they're originally accosted, would that satisfy an aggravated kidnapping?
I don't think just the moving would, but taking them away from the opportunity of escape, taking them away from anybody hearing them, taking them to a place where they're able to get something else to assist.
And your
them.
point is that should, and I think Justice Stiegel says that should be something the jury should hear argument about. And
Yes.
discuss.
He would agree, take it, that we should judge the aggravated kidnapping based on the jury instruction that was given and not the statute that has other elements that the jury doesn't know anything about.
Yes, I think because the trial prosecutor limited it in the jury instruction, you have to go with the jury instruction. I think if they would have left it as it was originally, I think it would have been okay to consider both of those elements.
I think that's what the Court of Appeals did when it analyzed that issue.
Because there was evidence of tying her up with the Apple cord, charging cords and things, and telling her not to cut herself loose until he was gone. So they might have used that.
Just out of curiosity, I guess, that was the state's instruction, proposed instruction that became the actual jury instruction on the elements of aggravated kidnapping?
Originally, it had both in the proposed instructions for the judge to consider. They had both the commission of a crime and sorry.
Facilitate
This-
flight.
Yeah, thank you. To facilitate flight was both in there. At the time that they were doing their last jury instruction conference was when that got changed just to commission of a crime. Other questions? Thank you.
Thank you, Your Honors, and may it please the court. I just have just a couple of quick points. First, regarding the requested jury instructions. Again, I checked yesterday and I have right here, the proposed jury instructions only say commission of any crime. That's at record 124. And they'd never discussed flight at all at the instructions conference. 11 page 70 or 790 lines 1 through 22. But on that point, I would absolutely agree that the Court of Appeals, going to Justice Biles' question, that the Court of Appeals clearly used the flight to affirm the kidnapping. That was the only way I read the opinion. I didn't read it as affirming on any other basis but the flight. And so I think that at the very least, the Court of Appeals needs to be reversed, obviously, on that, because that element was never put to the jury. But back to a quick point on the self-representation. I just want to note the language of Section 10 of the Kansas Constitution. The accused shall be allowed to appear and defend in person or by counsel. Now, I understand this record does not put Mr. Couch's abilities as a lawyer in the best light. But again, that's why this is structural error. That's why this is structural error, because it's such a bad idea a lawyer who represents himself as a fool for a client. That's why there is no harmless error analysis, because you shot yourself in the foot once you started. Now, again, I understand where counsel referenced Mr. Couch stating he was going to bite his attorney's face off. That did happen. That did happen right before his motion was denied. But again, right before. It happened right after Mr. Couch made argument as to why he was sick and tired of being with his lawyers and saying that his lawyer had accused him of a crime. And he made that comment when his lawyer was telling him how much he needed a lawyer and how she didn't say that. Again, it's all part and parcel of Mr. Couch wanting to be in control. But before that, and I urge this court, I urge the entire court to read the entire pretrial proceedings. They are not very long. I think that as I did that yesterday, it shows that this problem of his obstructiveness and his violent obstructiveness, again, this was not going to be an easy trial if he represented himself, but I think he would have stayed within the bounds of conformity enough that he should have been given the chance as the Kansas and federal constitutions require before it's terminated.
Counsel, I want to narrow this focus a little bit. Are you saying that no matter what a defendant does, say it's verbal abuse and violent, but just verbal abuse and disrespect for the court, disrupting the proceedings, whatever the defendant does before the motion gets ruled on, can't count? In other words, the court has to grant self-representation and then, basically give them a chance no matter what, and then take it away.
The only
Is that what you're
exception,
saying, or a matter of degree?
no, it is the first, but the only exception is you have to give it to them and you have to let them try, unless, again, under Bunyard in those cases, there is such evidence of such severe mental illness that the decision to waive it can't be known. But yes, absolutely correct. Yes.
What if he tells the court, I'm not going to follow the rules?
Then as soon as he does not follow the rules, the court is well within its power to terminate that representation it just gave him and appoint standby over his objections and remove him from the courtroom if necessary. Like I said, I'm not saying that once you give him the right, he can do whatever he wants. I'm just saying you have to give him a chance to conform himself to allow him his right. And if he doesn't, then you can terminate. But he has the right. He must be allowed to exercise it. He is an American and a Kansan. And with that, that's.
Doesn't McCaskill say, and I quote, "An accused has a Sixth Amendment right to conduct his own defense, provided only that he knowingly and intelligently forgoes his right to counsel and that he is able and willing to abide by rules of procedure and courtroom protocol."
Yes, and I think that once you're, and once you say yes, you agree to that. If you don't follow through on that agreement, then the judge terminates. Like I said, because the judge can terminate, there is no danger in allowing someone.
But it says, and he is able and willing to abide by rules of procedure and courtroom protocol. So if that last part of the statement in McCaskill is not met, either by the defendant directly or by his behavior, indicating, I will not follow the rules of procedure and courtroom protocol, does he still have an unqualified right, or is that the difference between unqualified and absolute?
I still believe it's unqualified because I think that that goes to the fundamental heart of unqualified versus absolute. It is unqualified. You can be the biggest jerk in the world, but you're still qualified. So even if you say you're not going to do it, but once you get it and you follow through on that, it's over. And again,
Difference between absolute and unqualified then.
because unqualified means no barrier to entry, whereas absolute means no limit. So with unqualified, there is no barrier to entry to get it. I have no qualifications. I get it, but it's not absolute. I can't do whatever I want with it. Once I step over the line, it's done. And again, I would say that regardless of whatever any case law says, Section 10 of the Kansas Constitution explicitly, as recognized by Ferretta and on page 813, footnote 10, recognizes an explicit right to self-representation reserved to the individual. Again, allowed to appear and defend in person. That's as clear as it gets. You have to have the opportunity. And without that opportunity, there is structural error necessitating a new trial. And I have no further remarks. I willing to take any questions. Thank you, Your Honor.
Thank you, Mr. Mann, and thank you both counsel for your arguments. The court will take this matter under advisement.